You're sitting there wondering, am I going to trial or is this case going to settle? Maybe the insurance company is ghosting you or they're lowballing you so hard it doesn't even cover your medical bills. And without answers, you're stuck. You're wondering, do I need to delay treatment? You're dreading legal costs, unsure if you're walking into court. I'm Ted Spaulding. I'm a personal injury trial attorney here in Georgia, and I've helped clients navigate this exact decision for over 20 years now. And in this video, I'm going to break down the real factors that decide whether your case settles or it ends up in front of a jury. And the point of this is so that you're not caught off guard and you finally know what to expect. Let's talk honestly about what happens after you file a lawsuit in Georgia on your car accident case. A lot of folks immediately worry that the second you file a lawsuit, you're going straight to court. And I get it. You're worried about facing a judge, standing in front of your peers, which are your jurors, and you're intimidated. And naturally so, it's understandable. You don't do this every day like we do here in Georgia. But here's the truth. Most car accident lawsuits in Georgia never go to trial. The last statistics that I saw, and it matches with my general experience as a trial lawyer over the past 20 years, is that 95% of cases that go into a lawsuit settle without being tried to a judge or jury. So you have a very, very, very good chance your lawsuit is not going to end up in front of a jury. It will resolve at some point through what we call a settlement. Now, you might be wondering, why is it such a high percentage that do not go to trial? Well, it comes down to practicality, right? It's practicality for you and for the insurance company on the other side. Trials take a lot of time. Often. They are often expensive for both parties, both in legal fees, especially for the insurance company who are paying by the hour for their attorneys, and for you through your attorney in building all the evidence that you need, getting exhibits, calling witnesses, experts. All of that can be very expensive. And then the most important is a jury trial is always, no matter how strong your case is on either side, is always somewhat of a gamble. You never know what 12 jurors are going to decide, especially when in this civil situation, a car accident, we're talking about monetary awards. You don't know what the jury is going to do. And the secret is trial lawyers don't either. We have some good assumptions that we can make given our prior experience, what we've heard in general about those different venues in the past couple of years. They can help us guide toward what is likely outcomes. But I have tried a number of cases. I've had cases where I thought there's no way we're not going to get a really big number, and we didn't. And I've had cases where I'm thinking it is just a moonshot that we're going to get a big verdict, and we get a big verdict. So oftentimes it comes down to who are those 12 jurors, and you do not know until the day of trial who your 12 jurors are going to be. So it is inherently risky for both sides. But this is why most cases ultimately settle, because of that risk. But there's some important exceptions, right, too. That 5%. When are you going to fall into that 5%? And your case is going to need to be tried. You probably want to know that, right? Because it's real important. It might be rare, but you need to know when it does. So what I'm going to do is I'm going to break down exactly how these cases play out in Georgia and help you figure out what you can expect in your particular case. Is it likely to go to trial or is it not? So after a car accident in Georgia, the first step is always you're filing a claim with the insurance company. Maybe you file it on your own. Maybe it's the other driver. It's a company that's involved. You're filing it with them. You're filing it with your insurance company. The insurance companies, they'll start an investigation on their own. They'll look at the police report. They will pull any body cam video, any video from around the area. They'll get your medical records. They'll get statements from people who are involved. If you've hired a lawyer like our team here in Georgia, we'll gather all of the evidence for you. Insurance companies do it on their side. We'll do it on ours. We'll pull all the same video. We will get a copy of the police report. We'll get all your medical records. And then we will create what's called a demand package. And that's basically a very detailed letter for us. We do real detailed demand packages to give our client the best shot at settling their case before a lawsuit is filed. And it's going to package up all the evidence, everything that we've collected, all your medical records, all your bills. It's going to give detail of all your pain and suffering that you've been through over the course, basically giving them a preview to how this case would be tried to a jury in hopes of maybe being able to settle it. And now here's the part that most folks don't realize. Many cases settle without even having to file a lawsuit. So that statistic I gave you earlier, 95% of cases in a lawsuit settle. Those are the ones that have to file a lawsuit. So if I had to guess what our run rate is, I would say we're probably 50-50 between the cases that we have that are in the pre-suit phase where we're gathering evidence, letting the client treat, of those that settle without even having to file a lawsuit. So when you have a case early on, you need to realize you have, first and foremost, at least a 50-50 chance that your case won't even need to have to file a lawsuit in to begin and continue the pursuit of your case. Then, of course, if you're one of the 50% that is in a lawsuit, then you hit that 95% that it's likely to settle once it's in suit. So you've got a really good chance that it ends here. It ends before a lawsuit is even filed. Now, of course, there's a lot of factors that go into that as well, and this video is not going to cover all of them, but at the end of the day, it's having a really good trial attorney that's handling it so they know you'll file suit and you'll try it if they don't resolve it. And they do a really good demand package, get all of the evidence. They're not missing anything to help your case and presenting it really well and strongly to get the best number possible pre-suit. You need that number to be high enough to not run the risk of filing a lawsuit and potentially going to court. So it needs to really be packaged up well. I think that's why our number is higher than a lot of other firms with pre-suit settlements, because they know we're going to file this lawsuit. There's no question. They know we're trial attorneys. So courts in Georgia, they even require most cases, all right, once a lawsuit is filed. So that's 50% that go into a lawsuit, okay? You're then going to be building your case, and then you're going to be in a position where the court's most likely going to force you into what's called a mediation or an arbitration of some sort, meaning pre-trial resolution of the case, because judges know if we can get the parties in a room together, there's a strong chance this case is going to settle. So you're likely going to be forced to do that anyway. Now, before you get there, once you're in a lawsuit, so you weren't able to settle it pre-suit, you're then going to go through the more formal building of your case. That's where you have subpoena power through your attorney. You can subpoena records that you weren't able to get pre-suit because they would not provide it, meaning the other side. You are able to take depositions where you get under oath testimony of witnesses, the at-fault driver, defendant, corporations, all of those sorts of things to help build your case. It's basically a preview of trial, but you have it as actual evidence at this point. This is all building toward a trial, but then you're going to have a chance to potentially sit with the other side in a mediation or the lawyers negotiating from their offices to see if we can get this case resolved. And remember, 95% of the time through that process, it's going to resolve. And again, for a number of reasons. So now let's go through what are those factors that determine whether you're going to hit that 95% of it getting resolved. And of course, you're wanting it to resolve in a good fashion for you. You're not just wanting to throw the case away. So how does that work, and what are those factors? So in Georgia, there are a few main reasons, and you should know about them, for why cases end up having to be tried to a jury. So you can spot those warning signs in your case early on to give you an idea. Is this one more likely to be one of those that's going to fall into the 5% that are going to need to be tried? So let's talk about the first one. And the first one is disagreements over who is at fault. So at any time you have a fault issue, as I call it, you have a good chance, or a higher chance, I should say, than the ones where fault is not a problem. Most of these car wreck cases, fault is not an issue, okay? So when it is, you're more likely to have to try your case because they're saying we don't owe you anything because we're not at fault. Now, what you have to know here, because this is a big one, is Georgia is a modified comparative fault state. Well, what does that mean, modified comparative fault? Well, what it means is they can say you're at fault, but you still have a right to recovery, meaning jury could agree with them, you are partially at fault, but you could still get a recovery. Now, how does that work? It's a comparative fault situation. So entire fault pie is 100%. How much percentage of fault is the other driver for causing the wreck, and how much of that 100% are you at fault? And here's how it breaks down. So if you are 20% at fault, the other side is 80% at fault in a comparative fault state like Georgia, you will still get a recovery. You'll get 80% of the full value of your case. So the jury is asked to value your case, value the percentages, 80-20, and you get 80% of that verdict. Now, in Georgia, in a comparative fault state, if you are 50% or more at fault of that 100% pie, you get 0. Okay? You don't get to share in the percentage. So that's real important. You need to be under 50%. All right? So it's 51-49 is your floor. 51% has to be on the other party for you to be able to recover anything. And then it's the percentage. So 51% or higher of the full verdict. If you're found 50% or more at fault, 0. So that's why you can see it when we're fighting over fault, they get to have two arguments. One, ladies and gentlemen, we think the plaintiff is actually 100% at fault for this wreck. We should owe 0. If you don't agree, folks, we still think he or she is 50% or more at fault, because here's what they did. They weren't looking. They didn't have their turn signal on. That's why we hit them. These sorts of things, speeding, everything else. If the jury agrees, it's still 0 for them. So they have two ways to get a 0 verdict in essence. And then, of course, the third is they're at least carving out a percentage, hopefully, to reduce the verdict. So it is a three-legged animal here where they're trying to reduce the verdict either all the way to 0 or by hopefully a big percentage for them, and they don't owe as much. So that's fault and one of the big reasons. The other is you're fighting over the amount of damages, right? This is the second big reason. Most cases, most car wreck cases, as I said earlier, that are in litigation, they're really fighting over damages. There's not a fault situation that's going to take you, almost all the time to trial. It is fighting over damages. Are you really injured? Did this really come from the wreck if you really were injured? How much wasn't? Should they pay all your bills? Should they not? And then, of course, how much, arguing over the amount of pain and suffering. They think it should be a low amount. We think it should be a large amount. And you're fighting tooth and nail over the amount of damages. Sometimes that fight is so large, there's such a gap in the theory of both sides as to valuation that you can't bridge those gaps in any kind of settlement, and you might as well just try it, right? So think of things like you think the value of your case is $500,000, all right? We, your lawyers, we think your case is worth $500,000 easy. Every day of the week, might even be more, but 500, I wouldn't settle for less than that. But the other side is saying, we only think it's worth 100,000. And no more. So we're not going any higher. You have a $400,000 valuation gap, as I call it. You got to go try your case. That's too big of a gap because they're not going to come up 400. You're not going to go down 400. And most likely, you're not going to split babies either. Meaning they come up 200,000 more, you come down 200,000, right? To resolve this. If you think it's worth 500,000 plus easily, why would you? Same for them. If they think it's 100,000 at best, why would they pay 300,000 even, which is still a big compromise. So you can see how damages in both sides having night and day different valuations of this case for whatever reason, whatever those components are, don't believe all your injuries, that sort of thing come from the wreck. You might have to just try your case. So the next reason, in my opinion, is what we call bad faith by the insurance company. Sometimes the insurance companies just do not play fair. Maybe they're dragging out the process. They're refusing to come to the table and talk rationally. They're ignoring evidence. They're not producing things that they're supposed to. Or again, they're just flat out refusing to offer something reasonable to take the risk away of trying the case. Under Georgia law, if we can show that the insurance company acted in what's called bad faith, and that's a legal term, a legal definition, they could owe you even more than the insurance coverage. It's a way to what we call bust the limits of the insurance. Insurance is kind of the ceiling of what you can recover. Your case could be worth $1 million, but if there's only $500,000 in coverage, you're typically only going to get $500,000. Even if you got $1 million verdict, there's only $500,000 in insurance. However, if that insurance company acted in legal bad faith in one of these multitude of ways, then you could go get that $1 million verdict and they owe all of it because they then were found to have acted in bad faith, either in settlement negotiations, they were not acting reasonable in adjusting the claim. They have a duty to do that, or hiding evidence, any of those sorts of things. So this would be another reason that your case needs to go to trial, because you have a chance to turn a $500,000 case into a $1 million case because you can bust their insurance. It's a unique thing. It does not happen all the time. It's rare, but it does come up. There have been very, very big bad faith verdicts out there with insurance companies acting atrociously in cases. It's unbelievable. The fourth reason is you might have a high profile case or a complex case, right? So one of those two. Some cases are just more complicated than others, quite frankly. Maybe there are multiple vehicles involved, or you're dealing with commercial trucks, or perhaps there's a lot of money at stake. There's high limits. There's big insurance companies. There's big companies that have assets. Think your Amazons, FedExes, things like that. And insurance policies sometimes can run into the multi-millions of dollars, 10, 15, 20 million dollars worth of coverage. We've had those types of cases. In these situations, everyone involved may be less willing to settle because of how large the potential is. Because remember, insurance typically covers, the ceiling. If you've got someone who's got assets, or they've got $10 million of insurance, they may look at it and go, that's a lot of money. And maybe the jury doesn't give that much, even though it's a horrible case for us. We know there's going to be a verdict and a big one, but it might be 5 million versus 10 million, right? That's a big, big swing. So sometimes this is what causes these things to go to trial. It's not because you have a great case, they have a bad one, or vice versa. It's just the pure math of it and all the insurance involved and all that. And of course, you could have a real high profile case. I had a trucking case in Savannah that got national attention. And that was real important because it was really, really horrible what happened. And that national attention, with cameras rolling and stakes being high and everything, neither side they wanted to blink, because this was going to be more than just that case. It was going to set some precedent and those sorts of things for the company, for the insurance, for the industry, that sort of thing. So we ended up presenting our case to trial. And that's what you got to do. If you have a high profile case, you might have to try that case. It's just the way it is. Now, you get that decision to make, but you got to get out there and make it. Now, the last one I've kind of carved out, and it's disputes over pre-existing injuries. It's technically part of the second overall reason, which is, again, you're arguing over amounts, but I wanted to kind of pull it out separate because it's really important, because it goes beyond some of the other reasons that there might be a valuation fight, meaning how much in damages. This one's real particular, which is pre-existing. Insurance companies love to claim your injuries were caused by something else. They were there before the wreck, either age, prior accidents, degenerative issues, which is kind of your age stuff with spine and that sort of thing. And if you have that, you are at a much larger increased chance that you're going to have to try your case. Especially if you have big pre-existing injuries, because that is something that can confuse jurors. At least insurance companies believe that, and so they're going to want to take advantage of it. And pre-existing injuries come up all the time. Almost every case has it to some extent, because everybody has something. Okay, unless you're a very young plaintiff, you're going to have age-related stuff. You're going to be in multiple wrecks, sports-related stuff, everything. Okay, it's rare to not have something. They're going to seize on any of it, and if they got real good arguments, they might not be reasonable with an offer, and you're going to have to try your case. So if you've got pre-existing injuries, you're at a much larger percentage chance increase that you're going to need to try your case. So be conscious of that. Pre-existing injuries is a big issue that could cause your case to have to go to trial. All right, now let's say your claim is one of those rare ones in Georgia that's got to go to trial. And you're wondering, what can you expect? So I want to talk through some of that now that we've gone through those factors that mean you may have to try it. If you're one of those, keep listening, because this will kind of give you some guideposts of what to expect, right? So first, your lawyer will work with you to get everything prepared. All that evidence is being built through what's called the discovery process. And then once you're getting ready for trial, your lawyer's putting together all the evidence. And so part of that trial prep is The lawyer will go through everything, all the questions that you're going to be asked. You are obviously the star of the case as the plaintiff. You're going to be on the stand. You're going to have to go through all of it, how the wreck occurred, how you were beforehand, how you were after, all your treatment, what this has meant for your life, things you can do now, couldn't do now that you did earlier before the wreck, how it's affected your life, possibly for the rest of your life, all of that. So all this will get organized. You're going to be super involved, multiple meetings with your trial team and prepping you for your testimony. And then, of course, prepping for all the other witnesses and evidence that needs to get in. Now, during the trial, both parties present their case, obviously. Your lawyer will talk to you about what happens through this, right? And so your lawyer is going to go through with the jury in opening statements and otherwise how everything happened, if there's a fault issue, how we see that, and why we think fault is on the other side, all your injuries, all your treatment, all of this. And then through witnesses, have that evidence put on for the jury through witness testimony, through exhibits, medical records, bills, demonstratives of surgeries, all of that kind of stuff. And then the other side gets to do the same thing, and they'll go through and try to poke holes, right? As you see on TV, the defense is trying to poke holes and say, no, here's why maybe it's a fault issue, or why this is a pre-existing injury, why they're wrong, and this didn't come from here, or they didn't need all this treatment and that sort of thing. And yeah, trial can be stressful. I mean, it is, right? Especially for lay people. There's no lying there. It's stressful for everyone, even trial attorneys that have been doing it for 20 years like myself. It is a nerve-wracking process, but with a good trial attorney, you can get through it. And it may take a few days. I've had several week-long trials. It depends on the complexity. Now, a day, you want to try your case as quickly as possible. People have low attention spans. You don't want to be trying your case over the course of a full week or longer if you can avoid it. But some cases, the proof that you have to have, because you have the burden of proof as the plaintiff, is going to require you to put on a longer case because you have a lot more witnesses than in a simple auto wreck, right? So it depends on the complexity of your case, how long it's going to take. And then you got to remember, how does this work when it comes to winning, losing, right? So if you win, the judge or jury will decide how much the other side owes you, right? That's the verdict. It is, in civil, it is a compensatory framework. So you're asking the jury for money damages. And the jury, if it's a jury trial, will tell you. If it's a bench trial, which are rare in personal injury cases, but they do happen, the judge will determine how much you are owed. And of course, if you lose, you generally get nothing, but sometimes you can appeal, right? So either side can appeal, but sometimes if you get zero and it's because some evidence came in that shouldn't have come in, those sorts of things, you can always appeal to see if you can get a retrial of your case. Now, one thing you want to remember is even as your trial starts, it can always settle, all right? The last trial I had back in March, the last offer was 2 days before trial. We then started the trial, and literally, because it went so well to begin with, opening statements and then putting on witnesses, after the first day, they were constantly coming to us with new offers because the case kept getting better and better and better. And it's exactly what you want to happen. And it was a week-long trial. Jury came back Friday about noon, but throughout, even while the jury was out deliberating, we were entertaining offers, and the numbers kept going up and up and up. And so it can always settle. I've had cases settle right after opening statements because the other side then wants to talk and go, okay, we see what's going on here. We misinterpreted this whole thing, whatever it is. Okay. Or it's going bad for you. You might want to be having your lawyer make the offer. So it can always settle even while the case is being tried. So another thing I want to answer, if you're still listening, is how long does the process take in Georgia? So the process, remember, in Georgia, there is 6 months standard of discovery. That oftentimes gets extended. It is rare to get everything done in 6 months. You know, it sounds crazy, but everybody is so massively busy. It's delay, 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 not our side, but on the other side. So you might have a year of discovery, not at trial, discovery. Then you get on a trial calendar. It could take another year or two. And we just got through a period because of COVID where we were having to tell people it's 2-3 years to get on a jury trial calendar because courts were shut down. Then they're behind. They're trying to catch up. And it was a mess. It's getting normalized again, but you're looking at after discovery, at least another year, maybe 2, before you're actually trying your case. So it is a very long process. So trial adds layers of delay. It just does, especially when you're in the busier counties. So if you're in a county, Fulton, Cobb, DeKalb, you're going to be in a situation where you have a lot more cases that are on the list waiting to try. And you got to work your way up. You start at the bottom and you work your way up the trial calendar to be the one that's ready to go. Number 1 is what you want. So you could be in it longer depending on which county you're in. The more complicated your injuries, of course, that year or more could drag out longer. I have several cases where the clients are still treating. I do not want to try a case while you're still treating because we're going to miss damages that we can't explain to the jury. What's the long term? What's your rehab? What's this? What's that? Do you need a second surgery? That sort of thing. So we always want to try a case when you're 100% done and have been done for quite a while, any big treatment, if not all treatment. So sometimes you have to constantly ask for extensions with the court because, hey, my client is facing another surgery. I got 2 of those right now where we've been dying to try these cases, but we can't because the client is still struggling through 2-3 years after the wreck, dealing with different procedures and surgeries to try to get better. And we got to let them get through that entire process. So that might delay it as well. Another question that I get is, should you be afraid to go to trial? And it's totally normal to feel uneasy or scared about the concept of trying your case. Most people have never done it. They've never been inside a courtroom, much less on the stand in front of 12 people and a judge, that sort of thing. But here's what I tell my clients in Georgia. Your best chance to get a fair settlement, to avoid trial and to be one of the 95%, is to 1, hire a trial attorney like myself and my firm so the insurance company knows you are willing to try the case. You are not hiring an attorney that they know, and they know which ones they are never going to try this case. And 2, you prepare it as if you're trying the case because you might have to. And when they see that you got a trial attorney and they're preparing it as if they're going to try this case, oh man, that's when you often get a fair settlement with the insurance company. Because again, if you're going to be in the 95%, you want it to be fair and a good settlement for you. You don't want it to be selling it cheap. Might as well just try the case. So having those 2 things will help you. No need to be afraid of trial. It's why you have a trial attorney. We or whoever you hire that's a good trial attorney will get you through the process and make you feel much better about your chances and about how to prepare yourself and all of that. We'll be by your side the whole way, all right? You won't be alone. We'll prep you. You're going to get tons of preparation. You're going to know exactly how to handle yourself on the stand, what types of questions are going to be coming your way, and then you can formulate so you know how you're going to answer these things. So you're going to have a lot of preparation, and preparation kills any nerves or fears, right? Being very prepared helps you get through any of that natural fear or concern. You might be asking, what should I do right now? Well, my opinion, if you're dealing with a car accident claim and you've got any kind of concern that this might have to be tried, your best idea is to talk to a Georgia personal injury attorney as soon as possible. Get answers to specific questions with details of your exact case. Every case is different. You want to bring all your paperwork, your photos, all of that, and talk to a trial attorney like myself. You can get answers to all your questions and feel better about where your case may be headed and what it means. So let's recap. Most car accident lawsuits in Georgia settle before they reach a courtroom, but some do go to trial. Usually that's when there's big disagreements over fault, over damages, or the insurance company's just being unfair. Or you've got pre-existing injuries that are big enough of an issue that you just can't get over that hump regarding them with the insurance company. The process can take a long time, like we talked about, but with the right lawyer, You can get through it. You can get the guidance you need. You can feel stronger about your case, less nervous if you are one of the rare ones that need to be tried, and it leads to success. Next up, don't want you to miss our next video, how medical bills affect your car accident settlement. This is a must-watch video if you're wondering how those hospital bills, your doctor bills, play into your final payout in your case. And you'll learn how to protect your rights from insurance tricks. So insurance companies, they love to play tricks. This video will help you with those types of things. These things can cost you thousands of dollars. So I'll see you over there at our next video.